All right. Good afternoon, everybody. This is Eric Hauge, Executive Director of Homeline, and we're joined by Homeline's Managing Attorney, Mike Vraw. And today is Thursday, June 11th, 1:30 p.m., and we're going to start our weekly COVID-19 legal rental issue webinar for an audience of landlords and property managers in just a moment here. Thanks for joining us. Reminder about who Homeline is. We are a statewide nonprofit. Our main program is a legal hotline that any renter in the state can call and get free legal advice in English, Spanish, Somali, or Hmong. And we've been doing these webinars since mid-April, and we'll continue to have weekly webinars for an audience of tenants and tenants and advocates, service providers every Wednesday at 1:30, and for landlords and managers every Thursday at 1:30. Just covering the most recent updates and any legal developments that have occurred, and we record all these and put them up on our website too. All right, with that, I think we did get some questions in advance, but again, feel free to submit questions throughout the webinar via the Q&A or the chat system in Zoom. And with that, I'm going to hand it over to Mike.
Thanks, Eric. Today we're going to talk about a couple of things at the beginning. Change in the eviction moratorium and exception has been expanded by the governor as of last Friday. And then we'll talk a little bit about sort of when evictions can be filed, keeping in mind the press conference that the governor had last night about the likely extension of the peacetime emergency declaration. But a quick update on kind of the big topic in landlord-tenant law in Minnesota, which is that landlords still, in almost every case, can't file an eviction currently. So this started mid-March. The governor issued an order that said that landlords effectively couldn't evict for most reasons that they typically evict for, non-payment of rent being the biggest. Well over 90% of evictions in Minnesota are filed for non-payment of rent. Also for any kind of ordinary breach of lease, so something that's in a lease contract like no pets, an unauthorized occupant like a boyfriend or a girlfriend living with the tenant would be the two most common types of breaches that we see landlords file evictions for: unauthorized occupant and a pet. Also for noise or for destruction of property. Those also are reasons landlords file evictions. None of those are fileable right now. Under the original order by the governor, the landlord could still evict. The two exceptions were for tenants seriously endangering other residents, and we'll talk about how that's modified in a second, but also for the specific statute on drugs, illegal guns, sawed-off shotguns, automatic weapons. If a tenant's been convicted of a felony, there's a list of guns that are considered illegal. Possession of stolen property and prostitution, those are found in the statute on your screen, 504B.171. So any other eviction, other than those two reasons, is not really something that a landlord can actually file right now. And it certainly won't be scheduled right now. Landlords are also barred from terminating residential leases during the pendency of the emergency. So again, the peacetime emergency declaration, that's the emergency that we're speaking about here. During that time, a landlord is not allowed to end a lease. Obviously, a landlord can't file an eviction. That's specifically brought up in the other part of the governor's executive order. So then the question has been consistently since these orders began in mid-March and have been renewed a couple of times now, can a landlord terminate a lease going forward? So we know that a landlord, if they had given a notice to vacate for the end of May, for instance, they gave it in April or even March, that if they'd given a notice like that, that would not be something that the landlord could enforce. The normal way to enforce that would be to go file an eviction on June 1st, using the May 31st example. And the landlord's not allowed to do that. They're not allowed to terminate the residential lease. But the question has been every month, okay, what about a future termination? So if the landlord gives a notice at the end of May for the tenant to vacate by the end of June or July, past the time when the peacetime emergency might be ended, is that valid? our view has been from the start, looking at that order from the governor, that any termination of the tenancy probably violates this executive order. And the violation has a penalty built into it. The Attorney General's office is the entity that's supposed to enforce this. It can be up to $1,000 for violating either the termination or the eviction rule, plus up to 90 days imprisonment. So it's a pretty healthy penalty against a landlord for doing this. And again, our view has been that a landlord that terminates a lease even into the future, because we don't know when the peacetime emergency will end, is violating that executive order. We have been in contact with the Attorney General's office since this all began, and we recently saw a letter from the Attorney General's office on behalf of a tenant that indicated that that is their view as well, that a notice given now during the peacetime emergency is violating the executive order, even if the notice to vacate official date when the tenant is supposed to go is past when the peacetime emergency declaration is set for. I don't know of any cases where they've actually enforced that, but to be honest, the Attorney General's office hasn't enforced many of these because they simply threaten to enforce them. And so the landlords back down in those cases. But if I were a landlord lawyer, which I'm not, I'm an attorney that works just on behalf of tenants running our tenant hotline. But if I were a landlord lawyer, my conservative advice would be to my landlord clients: you can't give a notice to vacate or a non-renewal or a notice to quit, whatever phrasing you'd want to use, during the peacetime emergency declaration. The conservative advice, I think, is to wait until the governor's peacetime declaration is over. One thing to note about all of this that I've just spoken about is rent is still due. I know that when the pandemic began, there were concerns, not just us, but a lot of the world was concerned that tenants would not be able to pay their rent going forward. And certainly landlords were concerned about that as well. The numbers, the percentages of tenants that have not been able to pay their rent in both April and May and now into June seems to be lower than everybody had originally predicted. Financial assistance, whether it was through the federal stimulus package, unemployment packages, has been more substantial than I think most of us thought it might be, and in some cases a lot faster. But there are still tenants that haven't paid rent since March, and landlords have been waiting to file evictions against them. And every month this goes on, where people are still out of work and the eviction moratorium goes further, it's likely that it will lead to more evictions sort of being bottled up or paused until the executive order eventually is lifted, and then we'll see exactly how many evictions will get filed at that point. And we'll talk about when the moratorium might get lifted here in a second, but let's talk about the slight change to the language to start. As I mentioned, the original eviction order said that a landlord, and we see the original language right here, could file an eviction if the tenant seriously endangered the safety of other residents. Okay, so that's a really specific group of people. And apparently there were some landlord, maybe individual landlords or groups of landlords, I'm not sure who got the governor's ear and convinced the governor to change this, but they decided this was worth the effort to change. And so the governor changed this order, I think it was last Friday. So instead of other residents, it says seriously endangers the safety of others on the premises. So it's got to be on site, including the common area and curtilage of the premises. And so others would now include, I think, a landlord or a landlord's agent or employee, where it would not have before. I think it would also include somebody delivering groceries or medicine, or just a routine guest. Anybody that's not a resident under the old rule, a tenant couldn't be evicted for endangering their safety. But now the broader definition, it falls into this larger group. The next phrase there, including the common area and the curtilage of the premises, is a strange phrase for my line of work. I've been doing landlord tenant law since 1996 here in Minnesota, and that word curtilage is sort of a loaded word in the legal arena. It's seen plenty in cases, but it's almost always Fourth Amendment search and seizure cases whether or not the police had a legitimate search warrant. Curtilage is a word used in those settings a lot. It's not used much in my line of work, but it probably means, well, it certainly means something like a garage on site or other buildings, but probably it extends to the property boundaries uh, for a complex. So it's not just the tenant's unit or just the hallway. It's a little, well, it's a lot more expansive than that. But I think once you get to the city sidewalk or the city road, then that is the end of the premises for this definition. Note also that the endangerment of others had to be a material violation of the lease. Okay, so this is kind of an exception to the exception, I guess, here. First of all, not every landlord in Minnesota has a written lease. You'd be surprised. Our best guess, taking 15,000 or so calls a year on our tenant hotline, is 5 to maybe 7% of landlords in Minnesota have handshake deals with their tenant. Wouldn't advise that for a landlord for sure. I'm not sure I'd even advise it for a tenant, but I think it hurts a landlord a lot more than a tenant to not have a written lease. But anyhow, in those cases where there's just a handshake deal, it's unless it was brought up and the landlord and the tenant more or less agree that it was brought up in the handshake conversation where the landlord said, hey, the place is yours for $1,000 a month. Tenant says, when can I move in? The landlord says the first, let's shake on it. Okay, that's probably a contract. The problem that you've got is proving exactly what was agreed to. So if a landlord tried to file an eviction under the governor's exception here, the landlord would have to show that there was a conversation. Hey, you won't endanger others or I can kick you out, right? Something like that kind of phrasing would be necessary in that oral lease example that I just stated. Even in a written lease, it might not necessarily be there. I mean, I read leases virtually every day that I work on our hotline. I get most of the emails that are sent to our email and attorney service, and people frequently send leases. And so I read a lot of leases. And what I can tell you to start is not every landlord uses the same lease. There's no one universal lease in Minnesota. There's 5 to 9 leases that are used fairly regularly by landlords, but there are a lot of kind of homebrewed contracts that might not have phrasing like that in them. So does this new eviction language change make a giant difference in the landlord-tenant legal landscape during the COVID-19 era? In my view, not really. I just don't think that it's that big of a change. I'm sure that there's 1 or 2 landlords that have a case that now fits into this situation that didn't fit before, but it's going to be a pretty low number. I don't think that there's going to be tens or hundreds or thousands of evictions filed based on this new change. If there's double digits that happen throughout the state because of this tweak by the governor made last week, I'd be really surprised. And we certainly haven't seen them flooding in since last Friday, as we're keeping a pretty careful eye on the cases that have been filed throughout the state, because there simply aren't that many being filed. But that's the change to the eviction law that the governor announced last Friday. All right, so now the kind of the $1 million question is, how long will the eviction moratorium last? And again, what we're talking about right now is the state eviction moratorium, which is sort of the first hurdle any landlord would have to get past in order to file an eviction right now in Minnesota, is can they, based on this state executive order. So we already talked about the exception for the drugs, guns, prostitution, contraband, and for the endangering the safety of others. But other than that, when can a landlord file an eviction? So this is confusing. The dates are confusing, but I always try to sort of touch on the same things. I think most of us now in Minnesota have seen the dial system that the governor's been using for when things can reopen. For instance, I believe yesterday, some restaurants or maybe all restaurants were allowed to open to a certain level. I can't remember if it's 25% or 50%. And how that was announced was in the newspapers and online, that there's these dials showing how much of the state is reopening compared to the shelter-in-place order that the governor had originally issued at the beginning of all this pandemic. Those dials are important and they matter for a lot of industries, but it doesn't affect the eviction ban. The eviction ban is tied completely to a declaration of a peacetime emergency, which is allowed under state law for the governor to pretty much declare that there's a list of reasons that count for when can a peacetime emergency be declared, and this falls into one of them. And these peacetime declarations, though, are 30-day increments. They last for 30 days at a time. And so we've had, let's see, it started in March, renewed in April, renewed in May, and we've got another deadline in theory coming up tomorrow. However, the governor had a press conference yesterday where he essentially said, I'm going to be renewing the peacetime emergency another month, and actually specifically brought up evictions as one of the reasons. It's not the only reason to have a peacetime emergency declaration remain in place. There's a lot of other things that happen statutorily that get triggered when the peacetime emergency remains in place. And if you take it away, then those go away. But evictions are certainly part of what the governor is thinking about. So it sounds likely that the governor is going to renew the peacetime or extend the peacetime emergency tomorrow, which would extend it to July, I think July 12th, since there's only 30 days in June. And then it could be ended then. It could be ended on July 12th. It could also be ended, I guess, the governor, I think, has the unilateral power to end the peacetime emergency at any point. The governor can say, you know what, I think COVID-19 is under control. The curve was flattened and we're seeing a mass decline in the number of cases that we're having. And so I think the governor could end the peacetime emergency at any point if they so chose. Or they could simply wait until this 30-day or whichever 30-day window we're in expires and then not renew or extend the peacetime emergency declaration then. The state legislature also has the power to either extend, which I don't see that happening because they don't need to because the governor can, or end the peacetime emergency. Okay, so this is something that could happen that the governor has no control over. When the governor declares a peacetime emergency now, that tomorrow, if that happens, assuming it does, the law requires, since the legislature is not in session, the law requires that a special session is immediately triggered. And we've all heard about special sessions during the last 2 decades, I think. We've seen a lot of special sessions that have occurred. Sometimes we've even had state shutdowns if there's no budget put in place for the state. I don't think that's possible this year because it's not the right year to have a state shutdown that would actually stop the budget. But anyhow, the special session, once declared, and it can either be declared by a governor by just announcing it more or less, or by doing this peacetime emergency declaration, at which point a special session is automatically triggered. Once a special session starts, it stays in effect. The special session stays in effect until the state legislature actually ends the special session. The governor can start a special session, but can't end one. Only the legislature can do that. Now, the state legislature, when they have their special session, could decide to vote to end the peacetime emergency. In order to do that, both chambers of the state legislature would have to agree to that. So both the Minnesota Senate, which is controlled by Republicans, and the Minnesota House, which is controlled by Democrats, would have to vote to end the peacetime emergency declaration. As I understand it, it's a simple majority. So all it takes is more, the 51% is enough to vote to end it. I think that's unlikely in the House. I think it might be very possible in the Senate, but you got to get both. One is not enough to end the peacetime emergency. As near as our reading of the statute that the peacetime emergency declaration is based on and all the accompanying information we've been able to find out about this, it looks as though the governor can extend this repeatedly, month after month, as long as a special session is either in place already or called each time. And so it's very difficult to predict when this might end. It depends on the governor. An answer might be found if we look at what the federal rule says. If we can just go forward a slide here. Yeah, the CARES Act. So the CARES Act might be something that the governor has in mind. I'm not sure. Again, we know people that work in the legislature. We know a couple people that work with the governor, but we have not had any heads up saying that the governor is going to extend the peacetime emergency ever, publicly stated to us or even privately stated to us. I don't think that there's more than a couple of people that know what the governor is about to decide. And it could be as honest as the governor saying, you know what, I'm going to wait until I get the last minute information so I can make my most informed decision about whether to extend the peacetime emergency. And the governor might have that sort of thought process in mind every time this is coming up. My hunch is that the governor announced that the latest extension, which would happen tomorrow, was worth announcing in advance because unlike all the other times the extension was announced, a special session has to occur. So this gives the legislature a chance to prep for that special session tomorrow and start immediately, hit the ground running. And by the way, there's no limit to what the legislature can consider in the special session. They aren't limited to just talking about the peacetime emergency declaration. They can talk about any other issues and try to pass whatever laws they want and see if the governor will sign them. But like I mentioned, when trying to figure out how long will this eviction moratorium go on for, what might be kind of lurking or looming in the governor's mind as a benchmark to shoot for is the CARES Act. So this is a federal piece of legislation. Normally in landlord-tenant law, federal law doesn't matter much at all. It's usually state law or even county or increasingly city laws that are having a rule. But the CARES Act does have an impact here. The CARES Act was passed in March, and again, we have not one party in control of the entire federal government. This was passed by a Republican Senate, a Democrat-led House, and a Republican president. So pretty bipartisan as things go these days. You can't say that about much. The CARES Act bans eviction filings through July 25th. Now this is just for non-payment of rent. So the unauthorized occupant, the boyfriend living there that we talked about earlier, the pet that's not supposed to be there, those would not be prohibited under the CARES Act. But non-payment of rent, which again, well over 90% of evictions in Minnesota, would be banned, by the way, including late fees. The state moratorium on evictions does not ban late fees. Interestingly, a group called Minnesota Multi-Housing Association, kind of a landlord rights/lobbying group, issued a memo a couple of days before the governor banned evictions through the executive order that called for a couple things to happen. One was no evictions should be filed through the end of May. It also said that landlords should be effectively not trying to collect late fees. But that's not in our state moratorium. It's only at the federal level. Again, this ban, the federal ban on evictions through the CARES Act, goes through July 25th, kind of on paper. But at that point, under the CARES Act, the landlord must give the tenant 30 days notice before they can file the eviction, basically saying, here's what you owe. And so realistically, a landlord can't file an eviction if the CARES Act is in play until almost the end of August. But let's see where the CARES Act applies, because it doesn't apply to everyone. It applies when there's any kind of federally assisted rental housing program. If you really want to know the broad umbrella that it covers, any place where VAWA, the Violence Against Women's Act, is in place would fall under the CARES Act protection banning evictions. But Section 8 voucher holders, for instance, would be a really big group where the CARES Act does have a role and would stop an eviction from being filed for non-payment. The hardest part to figure out where the CARES Act applies or doesn't apply is smaller buildings, 1 to 4 units that might have mortgages where the mortgage is backed by a federal insurance type approach, Fannie Mae, Freddie Mac, a federally backed mortgage. How many of those are there? Well, we're not exactly sure. This isn't the kind of information that's necessarily publicly findable, and it certainly isn't findable easily. It's the sort of thing that could be discovered in a court case with subpoenas and discovery, but it would take more time than an eviction generally has. So it's probably going to be up to the landlord to swear under oath, which is what many states are having landlords do when it comes to evictions. Some other states have opened up the eviction court filings again already. And in those states, they are typically requiring landlords to swear under oath that they are not covered by the CARES Act if they want to file an eviction right now for non-payment of rent. In truth, it's probably the only person in the world who can find out whether the CARES Act does apply to them, because they can go to their mortgage holder, the bank where they got their mortgage, and say, hey, I need to find out how this was insured. Is it Fannie Mae or Freddie Mac? And ask their mortgage originator or creator to tell them that. The tenant can't go get that information. They don't have any contract with the bank, so the bank's not going to talk to them. And as mentioned, while this information might be findable eventually through discovery process, it's not fast enough for our eviction process, which is a 20 to 30-day process on average from the day the landlord files an eviction, typically, to the day that the tenant has to go. We've looked at this as deeply as we can, and a lot of folks at the federal level have been studying this, trying to figure out how many people are covered by the CARES Act. Our best guess is 20 to 50%, maybe, of Minnesota rentals are covered. It's probably closer to 30, 35 is probably the most sensible bet. But it's hard to know. This isn't really a question people have been asking before because the CARES Act didn't exist before March of this year. And just to be clear, the CARES Act isn't just about landlord-tenant law. It's got a host of other components to it, but that's the part that matters for our line of work, landlord-tenant issues that we're dealing with. All right. As Eric mentioned, I think we have a couple pre-submitted questions, but not enough to fill a half an hour. And while I am perfectly fine speaking on a wide variety of topics, we'd prefer to answer whatever questions you might have, specifically about COVID-19, or if there's more time, we can try to answer sort of regular landlord-tenant legal questions. Be happy to try to help with those today. But Eric, if you don't mind, how about you give us our first pre-submitted question?
Yep. Tenant doesn't allow showings because of the pandemic.
Yeah, okay. So Eric has been posting things in the chat, the Zoom webinar chat, throughout today's session, and I'm sure he's going to post our link to what we have termed a position paper that we've written on when a landlord is allowed to enter in the COVID-19 era. So I'll start with the old rule, pre-COVID-19, which talked about when a landlord was allowed to enter a rental unit. It was created in the mid-90s, this law was. It says that a landlord is not allowed to enter a rental unit unless they have two things. Number one, a reasonable business purpose for entering. And number two, that they try to give reasonable notice. Those are really the two prongs that tenant lawyers and landlords have focused on since that law was put into place. And that law still is present. That statute has not changed since COVID-19 came around. The problem with that analysis is it leaves out kind of a key phrase in the statute itself. And I don't have the statute right in front of me, but it's something like under the circumstances it refers to. Under the circumstances. And so if you think about that for a second, the circumstances that we have right now are pretty unprecedented. And I'm pulling up the statute itself, so I'll give you the, under the circumstances of the intent to enter. So yeah, that's the right question right now to ask is what circumstances are we supposed to consider when it comes to a landlord trying to enter a rental unit? And we have absolutely gotten a lot of calls about the privacy question. We actually keep track of why tenants call our tenant hotline. We have about 75 different categories of calls. Normal years, the top three categories are always repairs is always number one. A tenant upset that the landlord isn't making repairs. Number 2 or 3 is evictions and security deposits. So they sometimes shift around. But since COVID-19 rolled around, evictions have taken the top spot. And privacy, which is usually somewhere near 7 through 10 on the top reasons why tenants call us. Privacy is now number 2 in reasons why tenants are contacting us about questions they have about the COVID-19 sort of situation that they're in. Understandably, tenants are very concerned about somebody coming into their home. Some tenants are more concerned about that than others. They might be immunocompromised, they're elderly, higher risk groups for lots of different reasons. And so they are more concerned about this right now than ever before. And where this gets to be most contentious, well, there's 2 main times when landlords typically enter a rental unit that's occupied. One is to make a repair. Usually the tenant is asked for a repair to be made. And so tenants are generally okay with a landlord coming in to make repairs right now, as long as they're getting enough notice so they can plan whether they want to be in the home or if they want to be out or if they want to sort of sequester themselves in a specific room, whatever they might want to do to help protect not just themselves, but also the employees coming in or the landlord themselves. The other point where we see a lot of issues come up traditionally and especially right now is showings. So the tenant has given a notice to vacate for the end of June or the end of July. And the landlord wants to show the rental unit to a prospective new tenant. And pre-COVID-19, that was a pretty standard approach. And I think that both tenants and landlords were more or less okay with it. Our office has actually produced a couple of books on landlord-tenant law. One was written for renters in mind, the other written for landlords in mind. And in both of the books, I believe we talked about the fact that, it doesn't make a lot of sense for a prospective applicant to rent a place without seeing it in person first. And I still have that view in mind to some degree, but we're just in a different era right now where in-person contact is risky. And the decision we all have to make in virtually every part of our lives right now is, when am I willing to take the risk to maybe contract this potentially deadly virus or expose somebody else to it if I already have it and I don't even know about it. And so it's simply changed everything about a lot of things, including this question: when can a landlord enter the rental unit? And so many landlords have decided kind of on their own, without anybody's input really, to simply end in-person showings. We're only going to do virtual showings. Sorry, because of COVID-19, this is how it's going to be. If I had to guess, I'd say that's the majority of landlords right now have decided to go that route, but not all of them, and certainly not a super majority. And maybe it's not even a majority. It's just a best guess right now based on what we've heard from tenants. And I think the virtual showing is a pretty good solution based on the situation we're in. It's probably the best solution. If a landlord says, you know what, I'm not okay with the virtual showing, current tenant, I'm coming in, you can't stop me, then we've got a real test of wills, I think, and who wants to blink first. Because what if the current tenant says, no, you can't come in, I'm simply not going to let you in? What does the landlord have for a remedy at that point? Well, I mean, they could call the police, and the police will almost certainly say, this is a civil matter, we're not going to get involved, because there's no crime being committed by the tenant not allowing the landlord to come in. So the remedy that the landlord probably would have, the traditional remedy, would be they could go file an eviction if their lease allows for it. The lease would have to say something about this probably in order to be an evictable offense or breach. And the problem with that is a landlord can't file an eviction right now, not unless it's endangering the safety of other residents or others. And I don't see how that argument could be made there either. So the landlord's remedy is pretty limited right now today. Now, I'm not saying that that's what's happening everywhere, but are there tenants that are saying you can't come in? There are. There are tenants that are saying that, and the ones that really stand their ground are ones that, like I mentioned, they or their kid or somebody in their home is seriously at a higher risk level than the general population, and they don't think it's worth the risk. So let's say a tenant does that. They stop the landlord from coming in, and the landlord says, you cost me a month's rent because I couldn't rent to somebody else, because I couldn't do an in-person showing. I guess the landlord would have a claim against the tenant for that. I don't know how that plays out. Eviction courts aren't the only courts that are closed right now. Conciliation court, which is the most common court that landlords and tenants sue each other in for money, because you can sue up to $15,000 in Minnesota. Conciliation court is more or less closed right now. In fact, most district court kinds of cases are closed right now, which is the higher level court than conciliation court. Courts have just sort of been, in a lot of ways, shuttered since the pandemic began. They'll open up again eventually, and people can start suing people for whatever they think they're entitled to. But for right now, I'm not sure what kind of immediacy the landlord has for a remedy if you've got a tenant that says you can't come in. And so it gives the current tenant, a little bit more bargaining power. I will say that there's a way to try to sell this, I think, to the prospective next tenant from the landlord's perspective, which is, hey, look, I would love to show you the place. That's what we used to do all the time. But we've got current tenants that have expressed this concern, and we're going to respect that. And so the only way I can show you the place is to do a virtual showing. I can let you see the inside of the building. You can see the hallway. You can see where the other amenities might be. I can walk you around the premises. If you have an empty unit, You could show that if there's one that's similar. I mean, you'd say, look, it's not the same one. It's not on this floor. It's not the exact same floor plan, but you can get a sense of what the inside of our apartments look like. It's better than nothing. But anyhow, the sales pitch part that I think a landlord could use with that prospective next renter is, hey, look, I'm a reasonable landlord, right? Nobody could have predicted COVID-19 happening, but know that if you decide to rent a place from me, I'm going to be the kind of landlord who considers the safety of their current residents and, puts that at the top of the list. And so I'm not saying it eloquently, but you could certainly do it that way when you're thinking about this and maybe sort of planning how to phrase this. But I think there's a way to turn this into a positive in the sales world to say, a lot of landlords are doing this and we are doing this as well, but virtual tours only until it's safe for us to do in-person showings of rentals that are currently occupied. And so that's not really a legal answer. It's not a statutorily based answer or case law based answer, but it's kind of a practical answer that if I were in the landlord game and I was a landlord myself, it might be how I'd phrase this to that prospective next potential renter. But it's a good question. Thank you.
Yeah, and then next couple questions are fairly related, so I'm going to ask them both at the same time here. When will evictions resume in Minnesota? When will the court system be opened up for evictions and/or lawsuits?
Yeah, and I really don't mind. I know the questions were put in advance, and we already had these planned slides, but I really don't mind covering that again because, look, this is the biggest topic, right? In landlord-tenant law, when will the courts be open up again for evictions? I honestly do wonder if the governor's office is thinking, hey, the CARES Act goes till July 25th and realistically till August 25th. Is there a way that we can run parallel to that? It's not that far off at this point. If the governor, in fact, declares the peacetime emergency tomorrow that was promised yesterday, more or less, then we're already up to July 12th. And so then it's just a matter of, 45 more days until you'd be mirroring the CARES Act. Although ideally it would require the same kind of warning notice from the landlord where the tenant would get an official notice, let's say July 26th. Hey, on August 26th, I can file an eviction against you unless you pay X. My hope is that the tenant could take that and use that in trying to qualify for emergency assistance or other kind of subsidies, whether they're government-based subsidies or charitably based or even religiously based subsidies. At present, I mean, a landlord's threat to file an eviction is sort of an empty threat. And so that would make it a lot more real. And one of the things that I've certainly been thinking a lot about as a tenant lawyer, and I know that others in our world have, and I know that landlords are thinking about this too, is what do you do with that tenant that hasn't paid? They haven't paid for months, right? They didn't pay April, they didn't pay May, they didn't pay June's rent. Do you rush down to the courthouse the minute the courthouse doors are open and file the case? And look, I have no doubt that that's going to happen. It's really difficult to predict the volume of cases that we're going to see. But even if we just have normal numbers of evictions, so we get about residentially, so there's honestly between 15 and 20,000 evictions in Minnesota every year. But some of those are commercial evictions, where you've got a mall evicting a tenant. Some of those are the far end, the last step in a foreclosure. That's the last phase of a foreclosure, is an actual eviction is filed. But residential evictions, traditional landlord-tenant relation type evictions, 13 to 15,000 of those every year are filed in Minnesota. Okay, so let's just assume for a second that there's no uptick in that number of evictions. Okay, that there's no higher number, that it's the same number of evictions as it was every year. I think that's absolutely not going to be the case because a lot of tenants have not been paying their rent. But what will happen is, because the courts have been closed, they've been on pause or bottled up, or however you want to phrase this, for months, even if it's just an average year. If we wait, at this point, it's going to be into July, it looks like. So then we're talking about 4 months. So that means that we would have, a third of the evictions in theory for the entire year that could be filed in one day. So why that's a problem is courts can only handle what they can handle. Look, if you've seen evictions in Ramsey or Hennepin County where they actually have housing courts and they are as efficient as courts get at pretty much about anything, they go through a lot of cases in a very short amount of time. If you've seen it, you know what I'm talking about, the actual housing court calendars. There's a lot of cases. A lot of times the tenants don't show up because they don't figure they have any defenses, or maybe they can't get to court, whatever the reason. Maybe half the cases the tenant doesn't show up. But then the other half are still gone through really quickly. You can have 30, 40, 50 cases in a 2-hour block, right? But if we take all the cases from a 4-month period and throw them all into a 1-day or 1-week filing, it could just be a massive number of cases for the court to try to figure out how to handle. Now, my hunch is that Hennepin and Ramsey County, where they have housing courts, they can figure out how to do this because they deal with volume already. They've done that all along. They could open up more days. Instead of 3 days a week, it could be 5 days a week. They could have morning and afternoon sessions. They could even have evening sessions if they wanted to. My biggest concern about sort of what's referred to as judicial economy or judicial efficiency doesn't become the only goal when it comes to these eviction cases. These are court cases, and that means that both sides have a chance to say whatever they need to say to assert their rights. And so these aren't they shouldn't be eviction factories. That's not how they're supposed to work. It's supposed to be a chance for both sides to assert whatever they need to assert. But like I said, outside of the 2 metro housing court counties, if you take 1/3 of the evictions and put them all in a 1-week period, I'm really concerned that those courts, which are almost always district court judges that are running them, those are elected judges, not appointed referees that become specialists in housing court issues like they do in Hennepin and Ramsey County, that those judges might be so interested in judicial efficiency that they forget the part about it being a court case. And so it's a real concern that I know our office does and lots of tenant advocates do around the state. The state has passed a law relaxing the statutorily required limits or deadlines for a lot of court things. So I talked earlier about an eviction taking on average 20 to 30 days when a landlord files it to the last day the sheriff comes out the second time to remove the tenant. Part of that 20 to 30 days is that if a landlord files an eviction in Minnesota, they're guaranteed court, an initial hearing at least, within 2 weeks. That's under the law. However, the state, like I said, passed a law, the COVID-19 pandemic, that essentially let courts ignore time requirements and time limits on things like statutes of limitations because courts were effectively closed for a few months. So in theory, that 14 days to be into court rule might not be honored by the courts. I know that I've heard that in Hennepin County that they plan to still abide by it, which I think is a lofty goal, and maybe they could be that efficient. I'm not sure. That I think they'd have to bring in extra judges or referees to probably manage it, and court staff. And you've got the additional problem of how many people can you fit in the courtroom if you're going to be doing these cases in person with the COVID-19 concerns. If you're going to be doing them by Zoom or by phone, there's going to be electronics issues that are going to, we've all been involved in Zoom or Skype calls where things didn't go smoothly and it takes 10 minutes to get things ramped up. And that might not sound like a big a deal, but if you're talking about a 10-minute delay and you've got 40 cases, that's 400 minutes that in theory could be delayed because each case you have to get contact with the parties and make sure that it's all established and everybody's speaking, they're not muted, all kinds of little things that just chip away at how much time these cases are going to take. So while a landlord can file a case, is that the right move? Is that the right move to rush down to the courthouse and file an eviction? And every landlord is going to be doing a cost-benefit analysis when it comes to deciding whether to file an eviction against a tenant. If a landlord does file an eviction against a tenant that hasn't paid from April on, and they win the case, the landlord wins the eviction case, it's really important to remember what a landlord wins if they win the eviction. They win possession. That's it. They win the keys. They win the right to repossess the rental unit. That's really not what most landlords are hoping for when they file an eviction for non-payment of rent. In truth, they want to get paid. And that's how a lot of evictions are ended in Minnesota, is the tenant comes up with the money, maybe on their own, maybe through friends, family, emergency assistance, social service providers, whatever. But they come up with the rent and the court filing fees and the late fees and all those things, and they get to stay. It's called redemption. It's actually built into the law. They're allowed to stay. And most landlords are fine with that. I mean, they're not thrilled about it because court took time and effort, but evictions are just sort of a state-sanctioned collection effort in Minnesota. That's how I'm not sure that it was designed that way, but that's how it is right now. But the landlord doesn't win money if they win an eviction. So if a landlord has a tenant that hasn't paid rent for 3-4 months, and they decide they want to run down to the courthouse to file an eviction, they should be doing that only because they've thought it through and decided this is the best move for me. If the landlord ever wants to get paid that money back, those 3 or 4 months, a smart landlord, an experienced landlord, is going to understand that their only chance probably of getting that is if that tenant sticks around. So, all right, let's just assume that the tenant gets a job late in the peacetime emergency declaration era, 2 weeks before, for instance. So they'd been unemployed and they weren't able to collect unemployment because they didn't have the right kind of job that qualified or whatever, but now they're working again and it's a decent job and they can afford their rent going forward and maybe a little more. I think there's going to be a lot of payment plans agreed to between tenants and landlords. And these they can be as simple as you want them, or sometimes a little more complicated, but here's what a common payment plan is going to look like. The tenant, let's use $1,000 for rent because it's an easy number. The tenant owes $1,000 per month in rent, and the landlord is ready and willing to file an eviction, let's say on August 1st, because the tenant hasn't paid for several months. But the tenant's got the money flowing again. So they go to the landlord comes to them and says, do you have any money? Do you want to try to work out something to stay or not? And the tenant says, well, look, I can't pay you all $5,000 that I owe you. I don't have that money. But here's what I can do. I can pay you $1,500 a month until I get caught up. Now, would that take time? Absolutely. But what does the landlord have to lose there, especially if the tenant puts some money on the table that day? If the tenant comes in with $1,000 and says, I'll give you this $1,000, but we need a payment agreement, and let's write down what we're agreeing to, which is, by the way, there's a partial payment statute that's technically a defense to evictions. And that's really what it wants a landlord to do, is to write down the agreement that's being agreed to if there's a partial payment considered between the landlord and the tenant. But anyhow, the tenant offers that $1,000 right up front and then says, I can start paying $1,500 a month on the 1st of next month. Is a landlord wise to accept that? Well, again, if you want to get paid, maybe so. Because again, if you're in the landlord game long enough, you realize, okay, if I get that person out of there, I can chase them for money. I could take them to court and get a judgment against them. True, you could do that. That doesn't mean you ever see the money, though. Tenants can be difficult to collect from. That's just how they are. I mean, tenants are sort of nomadic by nature. A lot of them are. They move from place to place. So they can be hard to find. Trying to collect money from somebody who's out of state gets a little bit trickier. Maybe they won't have any more income anyway. So even if you get a judgment, you're not going to collect the money. If you really want to get paid by a tenant, it's by keeping the current tenant. If you want to get paid by a back debt, the odds of you getting that money from the tenant once they leave, quite a bit lower. And again, I'm not saying that that's some sort of legal conclusion. It's a practical conclusion that I've talked about 200 landlord groups around the state over the years. That's what they say. It's really hard to collect from a tenant once they've gone. And I don't doubt that that's true. You can get a judgment, which makes it really difficult for them to ever get a loan again for a car or especially a house. You could turn it over to a collection agency, but again, that doesn't necessarily put money in your pocket. The other option the landlord is going to have, though, is to say to the tenant, hey, look, I'm going to go file an eviction against you. When you applied 8 months ago, a year ago, there were no evictions on your record then, and I'm assuming you don't want any evictions now. And truth is, I don't want to file an eviction against you, but the governor's moratorium is lifting, next Friday. So if you want to give me the keys by next Friday, then I won't file the eviction against you. Give me the keys and a piece of paper saying you're getting out, and we'll be done. I know some landlords that actually pay tenants to leave in that situation. It's going to cost me $300 to file the eviction. I will give you $300 if you leave. Why would a landlord pay somebody who owes them $5,000 to leave? Well, you're going to get possession faster, and it's probably going to be less friction. And you've also given the tenant an incentive to, this is the landlord's giant fear typically, is that the tenant's going to trash the place on the way out the door, which doesn't happen as often as one might think. Certainly, landlords are afraid of that potential. eventuality, but if you do this long enough, you'll realize most tenants don't go that route, but it's a fear that landlords have. But if you give the tenant an incentive, a monetary incentive to not trash the place, and you show up and you look around and make sure it looks okay before you give them the money, then it might be a way to avoid the eviction process altogether, get possession back of your rental unit faster, get it leased up to somebody who's able to pay the rent right away. So I don't think every landlord's going to file an eviction. There's other options that a landlord has, but we have no illusions about this. There's going to be a lot of evictions filed. Again, even if we were just talking about an average year's worth of evictions, we'd have a massive influx happening the minute that it's legal for a landlord to file. And there's going to be logistics issues pretty much guaranteed for every court in the state in trying to deal with that, which means there's logistics issues for both landlords and tenants going forward. Wow, that was a long answer. I'm not even sure I remember what the question was, but hopefully that was sort of on point.
All right, so a couple questions here. Landlord has a month-to-month renter that's paying rent but refuses to leave. Landlord did have an eviction order served on the tenant, but it was canceled or suspended because of the governor's order. Landlord wanted the tenant gone because they had never been able to pay rent on time. Tenant is now asking to do a new lease. Can we as the landlord legally ask that they pay rent in advance 6 months, for example, 6 months or no lease?
Wow, there is a lot there. First of all, I'll mention Minneapolis's new ordinance about capping security deposits and first and last month's rent might play a role. I'm not sure what city the landlord is in this context. So that might be a consideration. That rule's in effect now too. It started June 1. So I'd advise if you're a Minneapolis landlord and you're thinking about all those sorts of things that you check into that ordinance that just passed. We talked about it last week during the program as well. But I don't think that the tenant can force the landlord to renew another 1-year lease under the COVID-19 rules. Probably what we're left with right now going forward is once the lease expired, or if it was month to month originally and each month that it was ending, then probably what we have now going forward is a month-to-month lease, assuming the rent's due on the first of the month, which it is for most people. It's not paid weekly or every 2 months or something like that. It's probably simply a month-to-month lease going forward. And so that's the default that we've got for both sides, unless both sides want to agree to something. But as far as something like demanding payment up front of 6 months, I don't think a landlord can force that. I don't think the tenant can force the 1-year lease either, though. Although I guess another consideration for the landlord, just not knowing when the eviction moratorium might end, so when you'd be allowed to terminate the tenancy finally, there is always that chance that we're going to keep going with the eviction moratorium. Let's say the COVID-19 numbers in Minnesota flare up and don't flatten like we're all hoping they do, or even start to go lower. And the governor keeps this COVID-19 rule in place into, let's say, late October or even November. Do you really want to give a notice to vacate to the tenant for the end of December or January when it's going to be the most difficult to re-rent the place versus a warm weather move out for the tenant, which is typically better for both the tenant and the landlord because that's when people want to move in Minnesota. So the tenant doesn't want to go at the end of January and the landlord doesn't want to have to try to re-rent then. So I'm not sure, at some point, maybe it makes sense. Let's say we're into August and the governor isn't giving any sign that they're going to let up on the peacetime emergency declaration. Maybe at that point you say, hey, tenant, I want to do a 9-month lease with you so we get to the warm weather of next year. But there's a lot of things to consider. But the 6-month prepayment in advance, throughout the rest of the state, it would not be illegal. But again, the tenant could just sit and say, I've got my month-to-month lease. Minneapolis, it might not be legal under the new ordinance.
All right, and then let's see here. We got one that came in. Is there any funds available for a landlord to apply to help with loss of income and expenses?
And this one you traditionally have answered, Eric. So what's the latest that you've seen on this?
Yeah, I'm not sure of. We haven't really looked at specifically at funds that landlords can apply to, but on our COVID page, we do have links to resources for tenants to apply, both, the unemployment insurance and then county-based emergency assistance. And then there's been a number of organizations and cities that have created their own local funds. And so I'll put that link in the chat again in terms of helping a tenant who maybe has lost a job. There are some resources. I'm not sure about what there is for landlords to apply to.
Well, but that might be the way the landlord gets helped, is the tenant gets caught up in rent through these organizations that you've just described. And that might be the way the landlord actually gets paid. The traditional approach, which is rent comes in. Is the amenities article online now? Did you post
Yes,
that?
it is. I can
Okay.
and I can put it in the chat.
Yeah, let me just talk about that for a second. We don't have any other questions in front of us, right?
Right.
That you see?
Nothing yet.
Okay. And we only have a couple minutes left. We just posted today another position paper on amenities in apartment buildings. And I'll just sort of summarize what the article is saying based on what we've been hearing from tenants that are calling us up and saying, hey, look, I can't use the workout room. I can't use the pool. And they're not generally trying to force that to happen. They haven't been since COVID-19 started. But what they have been asking is, wait a second, shouldn't I get a discount on my rent? Because one of the things I was promised was this workout room or the pool or the party room access or whatever. And it's kind of been a mixed response from landlords, whether or not tenants should be getting any kind of rent reduction or abatement or refund, however you want to phrase that, for amenities that aren't there. And you can see the position paper that we put together on this. I think the tenant has a claim. Since I'm talking to, I think, landlords right now, in my mind, this is one of those things. I've actually seen, you've all seen tenants that have posted things on Facebook or on Yelp or on various social media platforms complaining about their landlords in the past. It's pretty rare that you see a tenant talking about their landlord in a favorable way on social media, actually going out of their way to mention something about what their landlord did. But I've actually seen this, where tenants are saying, you know what, the landlord took away the pool and the workout area, which is a bummer. I really like those, but they gave me a $25 rent credit this month. So, I guess that's something. I'm not exactly sure how to phrase this, but I think this is a way, in some small regard, for a landlord to try to keep good tenants. If you've got a currently paying rent tenant right now, they're worth a lot to you. Right? If you're a big company, you've got ones that aren't paying rent, and you've got ones that are. And the ones that are paying rent, you really want to keep. They are among your most valuable assets as a landlord, good paying renters. And in fact, turnover generally is considered one of the enemies of landlords that want to make a profit. On average, landlords say that they lose about a month's rent when they have turnover. Whether it's seamless or not, that's the average, is it's going to cost you about a month's rent when you have turnover. So fighting against turnover is something I think landlords strive for, they should strive for, just from a bottom line standpoint. And in a small way, this is a cheap way to advertise to current residents. You know what? We're the reasonable landlords. We know that we're not able to give you everything that we promised in our slick brochures and online and our ads. And we just can't do it right now because it's not safe, or we haven't been able to do it because it wasn't safe. But we are going to give you, as a reward, because you've, been a good tenant for us, we're going to give you a slight reduction in your rent, or a kickback, or a gift card, or whatever you want to do, however you want to phrase this or sell it, because you haven't had access to everything that we promised. I explained this yesterday to the tenant group that we talk to every week, that if you go to McDonald's and you order a Big Mac meal and they give you the Big Mac and the Coke, but no fries, you're wondering, well, wait a second, you promised me the whole meal. Yeah, sorry, we're out of potatoes today. Well, give me the difference in price then, right? So when you promise a pool, when you promise a workout area, when you promise access to a party room, that's not the full rent, obviously. But some small amount, and I'm not even talking about a large, I'm serious, $25 on a $1,500 place might be the difference between a very happy customer and one who's mumbling about the fact that they can't go lift weights every day because that was one of the main reasons they picked that place over another. That small token can, I think, honestly have the effect of being a way to positively advertise to your current renters who, like I said, if they're good tenants, they are worth a lot to you.
All right. Well, that I think concludes our session for today, as it's 2:30. So again, reminder: you'll get a follow-up email with the links to next week registration and the recording for today. And again, on our website, all the recordings are available, as is that new uh, briefing paper on amenities that Mike talked about. So with that, we will call it a day. Thanks everybody for joining us.
Thanks.
Bye.